There are numerous grounds upon which the validity of a will can be challenged, and WBW deals with the most common of these on a daily basis. A will can be challenged if the testator lacked mental capacity, also known as testamentary capacity, when they made the will. This means that they did not understand what they were doing by making a will, or that they were suffering from a mental disorder or delusion that affected the will. A second ground is undue influence, which is where the testator has been coerced into making the will. A will can also be challenged on the grounds that the testator did not know or approve its contents. It can be sufficient to show simply that the will was made in suspicious circumstances. The law requires a will to meet many formalities, such as being signed by the testator and their signature being witnessed by two people who do not benefit from the will. If this did not happen, the will is invalid. A will is invalid if someone has dishonestly poisoned the mind of the person making the will against someone else who would otherwise have benefited from the will. This is called fraudulent calumny. A will could be effectively invalid if the testator and another person, usually their spouse or partner, each promised not to change their will without the consent of the other person, and the testator changed their will despite that promise. We will usually carry out an investigation by obtaining the testator's medical records from the time they made the will, and a copy of the will instruction file from the solicitors who drafted the will, or if there were no solicitors, statements from the witnesses. We will usually enter a caveat to prevent the will from being admitted to probate, which therefore prevents anyone from dealing with any large assets, such as a house or any land, any large investments, and any large bank accounts. Once we have sufficient evidence to move forward, we will usually contact the executors and beneficiaries of the disputed will and present your case. If necessary, you can make your claim in court, and if you are successful, the court will declare that the disputed will is invalid. If there is an earlier will, the court will allow that to be admitted to probate. If there is no earlier will, the estate will be in intestacy. Because court proceedings are lengthy and expensive, we usually recommend first attempting to resolve the dispute by mediation or negotiating a compromise settlement. Seeking guidance at an early stage from a specialist in inheritance disputes is key. Whether you are a beneficiary of a disputed will, whether you want to contest a will, or are an executor in a disputed will, we can help. Contact our client coordinator, who will be able to put you in touch with a member of our team.